All right, and we're live. Okay. Hey everyone, welcome to Legal Bites. I'm Alyte, I'm a lawyer, and on this channel we explain the law one bite at a time. So I wanted to talk about the Triller lawsuit versus H3 Podcast. This is actually the second lawsuit that's been filed against H3 Podcast. And it was the first one. H3 was cut out of the initial lawsuit filed by Triller, and now Triller immediately refiled just against H3. So I'll give all the background to the lawsuit, and then we'll go over the complaint. I wanted to talk about it because I thought it was really interesting, and I know that a lot of people seem to be very interested in this case too, especially people that are interested in YouTube drama. Anyway, and if you guys are enjoying this, I would love it if you give it a like. And if you really want to support the channel, we are on our march towards our first 10,000 subscribers. We just surpassed 3,000 recently. So we're on our way there. So if you want to subscribe, that would really, really help us. And if you really want to help us out, you can always support us on Patreon as well. So anyway, hi, Steve Fishman. Glad to see you watching. So I'm going to start by getting into some of the background here. So you probably have heard about the Jake Paul versus Ben Askren fight. It's part of this whole trend of YouTubers and TikTokers, I guess, starting to fight one another in MMA and boxing and whatnot. Don't know really how it started or why, but now it's become a trend. And so Jake Paul went up against Ben Askren, who actually is an MMA fighter, as far as I understand. Triller is a social media platform that supposedly Jake Paul maybe has a financial interest in. I don't know. I'm not sure. But that's what I've heard. Anyway, they had copyright distribution rights for the fight. And they had a pay-per-view service basically lined up, as is common for these kinds of fights. That was on April 17th. And since then, apparently there were a number of websites that on the day of the fight were streaming it on other websites that were unauthorized. They weren't licensed by Triller, apparently, supposedly. So Triller filed this lawsuit against various websites. That was on April 23rd, they filed the lawsuit. So I will show first this is not the initial one, but this is the first complaint that they filed against filmdaily.com, accesstvpro.com or .co, online2livestream.us. We don't need to go through all the names. I mean, they basically all sound a lot like that. No one really seemed to know about the lawsuit until they amended it a few days later to add, let's see, is it here? No, not that one. Okay, yes, where they added H3 Podcast and H3 Productions. And then all of a sudden, everyone was talking about this lawsuit. So there are maybe some reasons why they're filing this lawsuit. Some people have said that maybe it's a money grab. Some people have said that maybe it's for publicity reasons. I tend to agree with people thinking that maybe it's for publicity reasons, but that's just me. And part of that is because of the fact that they added H3 Podcast and H3 Productions a little bit late in the game, after they had already filed this lawsuit and the allegedly infringing action by H3 Podcast had already happened before the initial complaint was filed. Anyway, so after this complaint was filed, and then they filed an amended complaint to add these parties, the judge on his own, before anyone had responded to the lawsuit, none of the defendants, I don't even know if they were even served. The judge on his own basically said, you've got problems with this complaint, and he wasn't wrong. The main thing that he was focusing on was the joinder of all of these defendants. So in order to join a bunch of defendants like this, there has to be something that kind of links them all together. There has to be some reason why it's better to have all of these people in one lawsuit as opposed to filing a lawsuit against all of them separately. So basically because the judge and the plaintiff, Triller, they went back and forth for a bit here and there, kind of going over about this issue of joining these defendants, whether or not that was proper. And essentially the judge just said in a very entertaining order, basically said, no, you haven't given any sort of information here saying that really links any of these defendants together. They all happen to be websites that stream content. They may or may not have streamed your content. I don't know. But the only thing that really they seem to have in common is this allegation that you have a copyright on a certain type of content that these platforms may or may not have streamed. But otherwise, there's all kinds of facts that they would have to prove individually for each of these cases. So the court dismissed all of the defendants except for the first one, filmdaily.com, I guess. And so with that, H3 podcast was dismissed along with those other defendants. But the court did say that it wasn't limiting the plaintiff's ability to file a new lawsuit against them, but they would just have to file the lawsuit individually. So that is now what they did. So this order was on May 6th. So then 4 days later, Triller came back with a new lawsuit filed just against the H3 podcast. And it's not a very good lawsuit, in my opinion. I've got to say, I went through the complaint and I went through some of the content by H3 Podcast where I think this might be coming from. And I'm not entirely convinced that this is a good lawsuit, like really at all. And we'll go through that. So to do that, we'll go through the complaint and a little bit of the sort of going over the structure a little bit of the complaint, but then also talking about some of the claims. But really what I'm going to talk about, I think more than anything that I'm focused on is the accusations of damages, right? Because a lot of people are talking about how much is H3 Podcast going to be having to fork over to Triller for these claims if Triller can prove it in the first place, right? So one of the things that I want to show here is, let's see here, I'll pull this up. Okay, let's see if I can do this. Yes, okay, so here is the docket for this new case. And one of the things that I thought was really interesting is that here's the docket for the old case. The demand here, I mean, this isn't necessarily indicative of too much, but one thing that I thought was really interesting here is that, so against all of those defendants, the demand there was for just under $10 million. The demand here, just against H3 Podcast, is for $1 billion. Like that's insane. That's insane. $1 billion for whatever infringement or violations of the various federal laws that are alleged here. So we'll go into that, and we'll go into their other estimates for what they're saying that they are entitled to. Down at the bottom of the complaint is a section called the prayer for relief, which is where they list out how much money they think that they are entitled to, and for going down the line per claim. And basically, they're saying for a lot of these claims that they are out $50 million against H3 on its own, and that to me is just crazy. So anyway, okay, so let's get back to the complaint. One second here. Okay, so anytime you look at a complaint, there's always this box right here that talks about the firm that filed it. Then there's the court that it's in. So you can see that we are in the Central District of California, but we're in United States District Court. So we're in federal court. So it's filed in a California courthouse, but that is a federal courthouse in California. So we're under federal law here. So we've got Triller Fight Club 2 LLC versus the H3 Podcast. Okay, so the complaint has 6 causes of action here, as you can see. The previous complaint that was filed had 8. So it looks like what they took out here was conspiracy and breach of contract, which makes sense because I don't see anything in these facts showing that there was any sort of a contract here. And now that there's only one party, there can't be a conspiracy, right? Because a conspiracy involves at least 2 people. There's some sort of a plan between at least 2 people to do something illegal. So we have here copyright infringement, violation of the Federal Communications Act, 47 U.S. Code Section 605, violation of the Federal Communications Act, 47 U.S. Code Section 553, conversion, which basically means theft, essentially. You're converting something from someone else's property into your own property. Then there is violations of the Computer Fraud and Abuse Act, 18 U.S. Code Section 1030, and then vicarious copyright infringement. I don't know why they didn't list vicarious copyright infringement right after copyright infringement. That's a little bit annoying to me personally, just as a matter of drafting, because they're a little bit similar to one another. But anyway, that's kind of neither here nor there. But you can see at the top of the page, this is the case number, document 1. A complaint is always going to be the first document filed in any kind of a lawsuit. And it was filed yesterday on May 10th, 2021. So anytime you have a complaint, you have these different sections that you are going to be kind of looking through. So they're very formulaic, all of these filings. So you have the nature of this action, then you have jurisdiction and venue, because you have to be able to show that this case is properly brought in this courthouse, right? Because there's a federal court and there's a California state court, right? So you have to know which one to file into. Then there's the section talking about the parties, where they are describing who's the plaintiff, who's the defendant, and then usually there is a fact section here. But as you can see, there is no fact section here. They go right into count 1 for copyright infringement, counts 2, 3, 4, 5, 6. And then at the very end, they have what's called the prayer for relief, which I mentioned earlier. Prayer for relief, it just means basically bottom line, what are they asking for? What are they asking for each of these causes of action? So as to count 1, as to count 2. So I've kind of highlighted that here. And then at the very end, some attorney has to sign it, or if someone is filing this on their own without an attorney, then they sign it themselves, the party. So I'm going to go back to the fact that there is no fact section, which to me is a little bit of a warning sign, a little bit of a red flag, because in order for any complaint to stand, it has to have pled enough facts so that they have stated a claim that is plausible. Now, you don't necessarily need a fact section in order to do that, in order to accomplish that. However, it makes it a lot easier. And generally speaking, it's just, I don't think that I've ever really seen before this case, actually before the first 2 complaints that Triller filed in, I guess, the last lawsuit from last week. I don't think I've ever seen a complaint that didn't have a fact section. I don't think that I have. I mean, even with cases that I have seen that I've worked on, either as an attorney or as a law clerk, as a law student, as like a summer intern, where I saw cases that were filed by inmates in the California prison system, and those were handwritten, and I even literally had to sometimes cut up a complaint and then rearrange it and then paste it back together in order to understand what it was that they were talking about. They even had a fact section. So I don't understand why this complaint does not have one, especially because one of the benefits of doing it, of having a fact section, is that you can set out your narrative of what happened and how the plaintiff was wronged in this case. So anyone reading it, like the judge, for example, can kind of start to at least align this case with some sort of a narrative that may be beneficial to your case. So that's just a little bit of a warning sign to me about whether or not this complaint can stand. Ultimately, I do think that there is probably enough in this complaint that fact-wise, that we can kind of figure out what the plaintiff is alleging here. Ultimately, and part of that is because the facts, there have to be enough facts in the entire complaint, right? Even outside of the facts section, there have to be enough facts in this entire complaint that basically would give the defendant the ability to be on notice for what it is that they need to defend against, right? Because they have to be able to respond to this document. They have to be able to read this and say, okay, I kind of know what this is about. I don't agree with it because I have my story that I have to tell. However, I know how I can respond. That was kind of one of the problems with the previous complaint that Triller had filed against all of those people, was because they had listed so many people and not really many facts either. And so, any of those defendants in that case is probably going to be a little bit confused as to how to respond. So anyway, so that's just kind of one of the issues that I see with this case, and why I kind of have, just as an initial matter, a little bit of skepticism as to the strength of this case. And I say this not to be an a-hole to the attorneys that are working on this case, because, I'm a member of the California Bar. These folks are members of the California Bar as well. I never want to disparage people that are, other esteemed members of the California Bar or any other bar for that matter. But I got to say, I'm not really that impressed with this case and not terribly impressed with this complaint either. So, okay, so that's pretty much that. So basically, okay, my reading of this complaint, pretty much this is the facts that they've basically alleged throughout this whole thing. First, they say who Triller is and what they do. I didn't know before this case that Triller is a social media website. They do, and they also did the broadcasting for the Jake Paul and Ben Askren fight. So there's that. They also say who H3 Podcast is and what it is that they do. They also go through, the fact that Triller owns the copyright to those broadcasting rights for the fight. They say that H3 Podcast, so they allege that H3 Podcast intercepted the satellite signal for the pay-per-view broadcast, and then that they copied and distributed the broadcast to others for payment. So, and through their YouTube channel. So we can kind of go through that and sort of figure out where this alleged copyright infringement or where this alleged FCC or Federal Communications Act violation comes from. So because of that, I think it probably fact-wise would withstand a motion to dismiss, which is what the defense could file in order to make this case go away. But I think that as weak as this complaint is, because there's a little bit there, I personally wouldn't file a motion to dismiss on this one, because strategically, it would only give, I think, it would only give the opposite side an opportunity to sort of clarify and strengthen their case and their complaint. And it would end up just costing a lot of money. Anyway, so that's that. Okay, so let's go into some of the more detailed facts that we do know about this case that aren't necessarily in this complaint. I wish they would be, because that would be a much stronger complaint, and that would be it would actually make things a lot easier for the plaintiffs to have a stronger complaint and one that has better facts alleged in it. And for a lot of reasons. It also goes into the discovery stage, how they can strategize going about that and just making things easier along the way. But anyway, I think I've probably talked enough about that issue. But okay, so the basic facts of this case. So, as you probably know, on April 17th, they had a pay-per-view broadcast of the Jake Paul versus Ben Askren fight. Triller charged, I think, $49.99 for each view. And they now offer a replay for $23.99 per view. So that was obviously after the fight. So on the 17th, they had the fight. Then on April 22nd, 2021, H3 Podcast, hosted by Ethan Klein, streamed a video formatted podcast. They called it Jake Paul Fight Was a Disaster. So let me go to their channel here. I will switch this over just so you can see what it is that I'm talking about here. Okay. And that's actually not what I wanted to do. Give me 1 second. Okay. Okay. This is what I want to do. Okay, so this is H3 Podcast's YouTube page. As you can see, they have 2.89 million subscribers. They've got a ton of people already. They have, looks like about 3, maybe 4 videos per week that they put up. Each one gets, I mean, at least, generally speaking, 1 million views, but I mean, upwards of 4.4 million views over here. I'd say it looks like probably on average, they probably get around 2 to 3 million per video. So that's who they are. And it looks like they are a sort of YouTube drama channel. They do live streams that are like 2 or 3 hours long, talking about all kinds of subjects. Sometimes it looks like, I haven't spent too much time on their channel, but it looks like they talk sometimes about politics and those kinds of current events, but a lot of times about other sort of YouTube drama going on. There's a lot about James Charles. There's a lot about the Jake Paul fight. There's a lot about just, I mean, a lot of other YouTube drama stuff. If you keep up with that, I'm sure you already know. So the fight, or the video in question here, is the Jake Paul fight was a disaster video. And I'm not going to play this because even though I personally think that this would fall very squarely into all kinds of fair use exceptions, I'm just not going to, set myself up for tripping over that tripwire. But I just wanted to show kind of what this sort of looks like here that we may be talking about based on what I think the complaint is getting at. So on April 22nd, 2021, H3 Podcast posted this video. They live streamed it. And most of the video honestly didn't even talk about the Jake Paul fight. It looks like a lot of it talked about the other people on the podcast with Ethan Klein about various things that are going on. I think one of the guys is moving or something. I don't know. And then a lot of it was on the Derek Chauvin trial, the verdict that came out, and sort of a lot of the commentary that came out of that. And then it was like only like 10 minutes of this video that was dedicated to even talking about this fight, to be honest. And even less than that, there was about less than 1 minute that was played from this fight. And if you look at this video here, this is a YouTube video. And I don't know if you can see down here, but this is here, I will do this. So this is an unlisted video. It's unlisted. It looks like it's got 2 views. So it's not something that was put up for a public broadcast itself. It looks like the purpose of this video, the reason why it was even on YouTube, was probably for use in this live stream. And as you can see here, you've got Ethan Klein in the corner here. The entire time that he is, that they're showing this video, he's in the corner here and he's commenting on it. And both leading up to this point and during this point, he's kind of talking about how he thought that the fight was unfair because he thought that that Ben Askren is kind of past his prime and he's not in the shape that he used to be in before when he was at his prime. And so he's kind of showing this to highlight that fact. So like I said, the footage was, okay, we can say, so they started, I'm not going to play it, but they started talking about this at, I think it was like 1 hour and 26 minutes. And then they started to play a little bit of the audio from it. And it was like maybe like a few seconds of audio. And then they started showing the video at like 1 Oh, sorry, that was, they started talking about it at 126. 129 was about when they started playing the audio. And then like a few seconds later, then they started playing the video. And then by the time they got to, let's see, 1 hour and 29 and 33, they had already cut the sound. So the sound from this video that was playing in the background, they had the sound on for maybe like 15 seconds. And then after that, they had a total of 54 seconds of this footage. And as you can see here, this episode of their podcast is over 2 hours. And like I said, the subject is 10 minutes of that 2 hours. So I found it to be very, very interesting and probably useful to keep in mind when looking at this complaint. So, like I said, this video, or their typical videos probably get around 2 to 3 million per video. This one got 1,058,610. So actually not really one of their best videos, not one that they probably have made a ton of money on in comparison to a lot of their other ones. Like, for example, the one just before this one was, like I said, it was, where is it? Let's see. Here it is. James Charles' entire channel demonetized. 4.4 million views on that video just before this one. So that is very interesting because the allegations here kind of center on this idea that H3 Podcast has used an unauthorized broadcast of this fight in order to profit off of it. And they've alleged that they've violated so many different laws. One of them is copyright law. Two others are under, the Federal Communications Act, and et cetera. But basically, it all comes down to like this, as far as I can see, unless there's any information that I haven't seen. I mean, this is so far what I've found of, potentially the violating footage here. So if anybody has any information about other possibly violating footage here, use of Triller's content, let me know in the comments, because like I said, this is all that I found. And if this is it, if this is everything, and people are talking about, $50 million in damages and possibly jail time because the Federal Communications Act talks about possible jail time, I really don't think that this is a good case, to be honest, to be completely honest with you guys. I try to be as, middle of the road as possible in all of these. And I don't even necessarily like to give my opinion too much on these, because I prefer in these videos to kind of explain the law and sort of let people come to their own conclusions. But in this case, I really don't think that this is a good lawsuit. So going back to the complaint here. Let's go back here. Okay, so like I said, there are 6 different causes of action, and I'm going to give just a very light treatment here because I don't want to get too bogged down in the weeds. I know that that's pretty easy to do in cases like this. So the first one is copyright infringement. So we can probably all pretty much understand fairly easily what copyright infringement is. You have a work that is created by someone else or that is otherwise owned by someone else. And that includes something like a broadcast of a fight like this. So that potentially is a copyrightable work. And somebody else has the rights to it. Somebody else has the rights to distribute that. So if you then distribute it without getting a license to do so, you are potentially violating the copyright laws. So here they allege that plaintiff is the owner of the copyrights to the broadcast, including all undercard bouts and the entire television broadcast. They then say the broadcast originated via satellite uplink and were subsequently retransmitted to cable systems and satellite companies via satellite signal and or retransmitted via satellite signal to licensed content distributors, such as plaintiffs' authorized online platforms. So basically, they did this by pay-per-view. Triller owned the broadcast, or owned the rights to the broadcast. The broadcast was by pay-per-view. Then they say that the defendant, H3 Podcast, failed to obtain the proper authority or license from plaintiff to copy, publicly perform, or distribute the broadcast. And then basically they say that H3 Podcast illegally copied, uploaded, publicly performed, and distributed the broadcast via the internet with full knowledge that the broadcast could only be obtained by purchasing a license from plaintiff. So there's potentially two different things that I think some people are concerned about in this case, and that is by watching it through unauthorized means and then sharing it through unauthorized means. So what it seems like, so they mention here that they believe that the defendant obtained the broadcast through internet websites, cable and or satellite pay-per-view purchase intended for private non-commercial viewing. So they basically are alleging that H3 Podcast obtained the content through improper means. Basically, kind of like a lot of people that were watching these bootleg websites or whatever. But it seems like that's not really what they're suing them for, although they mention it here. There's just one reference to that. What they're really suing them for here, from what it looks like, is for illegally retransmitting the broadcast and publicly exhibiting the broadcast by illegally copying and uploading the broadcast to the aforementioned websites, basically to YouTube. And so, from what I mentioned before, it looked like the actual footage that they were showing was on an unlisted YouTube video. It looks like maybe someone from H3 Podcast had captured it somehow with some sort of software while they were watching it on a computer screen or on their TV or something, and then saved it to a computer and then uploaded it to their YouTube channel. Based on the fact that it had only 2 views, it seems to me that this probably was something that they were intending to use for the purpose of the podcast, and not necessarily to just put it out there so that people could watch this. Hey, Uncivil Law, new lawsuit is best lawsuit. Of course it is. Thanks for watching. Like I said, so what they were basically alleging here is that it's the uploading of the video, not so much the downloading of the video, but the uploading it so that other people can see it. That is the supposedly infringing work. And the reason why I kind of mention this is because I know that there was a oh yeah, you can see my cat there. Hey, Holmesy. Anyway, sorry for the distraction. There was I know a statement that was put out by Triller for people that had watched the fight through improper means, and they were saying, we're going to sue everyone and their mother who watched these things, and we're going to fine people. It doesn't matter if you're using a VPN, we're going to fine you anyway. But if you want to settle before we file and find you, even though they pretty much have no way of doing that, if you want to settle, you can come to this website and pay us $50, because that's how much, I guess, that it costs to watch the live stream or watch the live broadcast of the fight. So I know that a lot of people were intimidated by that, kind of thinking, am I going to be sued by this company? All I did was watch a stream of a fight, despite the fact that, it is correct that is not legal if you are watching it without buying a proper license to do it. Yes, thank you, Kurt. I will find you and I will sue you. So a lot of people were concerned about this, right? Because they were thinking that Triller was going to somehow come out of the woodwork and find them. I can tell you from having been a plaintiff's attorney that was filing a lawsuit against an employer for an employee who had been terminated trying to find the owner of a business, even though we had the business itself, for some reason, getting that owner and getting them served was one of the most difficult things to do. So even when you have someone where you have a pretty darn good idea of where it is that they are, and you want to, you pretty much know where they are, but you can still have issues with serving them with a complaint in order to bring them into the lawsuit. So even with that, so when you have these other websites that are these random named websites like whatever filmcity.co, I don't know. I mean, the idea that they can find these people is a little bit out there, and the idea that they can find on top of that people that are just random people that happen to watch, they happen to watch an illegal stream of a fight. The idea that they're going to find upwards of like 2 million people that they say had watched it illegally is just a little bit preposterous. It's kind of like, I don't know. It's out there. So anyway, so that's that part. So coming back to the complaint. So what they're saying is, I mean, that's basically the crux of it here, right? That they're saying, and they bring it under the federal copyright law. They bring it under the Federal Communications Act, 47 U.S. Code Section 605. They bring it under also Section 533 of the same. It basically is. I mean, they're looking at various different statutes here, but for the same kind of act. And like I said, I've said it several times now, that it's just the illegal downloading and uploading and republishing of this for their own monetary gain. And then turning that into conversion, they basically are saying that they are by downloading and then publishing and distributing that content to the world, they're basically acting as if it's their own. And what they're talking about is not necessarily the video itself, but the copyrights to the video. So the right to publish, the right to stream it, that what they're saying is that H3 Podcast basically converted that. They stole that so that they could make money off of it, whereas that money should rightfully go to Triller for whatever profits that they made from it. So that's at least the allegation there. So then they have violation of the Computer Fraud and Abuse Act. Is basically like I said, it's the same thing. And then vicarious copyright infringement. Same sort of issue here that it seems like. And by issue, I mean the same factual pattern that leads to Triller filing this lawsuit. So one of the issues that I have here is just looking at copyright. I'm not going to really go any further into the Federal Communications Act, those counts, or conversion, or the other stuff, because I'm going to talk first primarily about copyright infringement, because it is true that when someone else owns a certain piece of certain creative work, either music or a movie or a book or a broadcast of a fight, you can't distribute that creative work if you don't own it, if you don't own the copyright to it, and you also can't do it if it's not in the public domain. So it either has to be one of those: either you own it or it's in the public domain. There's an exception to that, and that exception is the fair use exception. It's talked about a ton on YouTube because, of course, YouTube is all about content, and a lot of that content builds on one another. Reaction videos are a big thing. Reaction videos are also a big source of conversation for fair use, because you're very often reacting to things that are found in pop culture, like movies, for example. My Legal Bites has some reaction videos as well, and we've also used other movies to analyze certain legal issues, and sometimes we've gotten pushback on the basis of copyright, and the response to that is usually fair use. So there are several different bases for arguing that your use of a certain copyrighted work falls into fair use. And that is if you're using it for purposes of news reporting or commentary or for educational purposes, or parody. That's a really big one. I know that, so this last weekend, Elon Musk was on Saturday Night Live, and there was one sketch. I didn't watch it, but I watched some commentary on it. But there was one sketch where they had, it was about, I guess it was like Wario was on trial for something or other, and Elon Musk was like as Wario. And I saw this video by Omni, another YouTube channel, and he was talking about, well, how is this possible? How does Nintendo allow for this to happen on, how is this not falling under like a DMCA strike or something? And the answer to that is it's parody, because they're using IP, recognizable IP that is copyrighted by Nintendo. Mario, Luigi, all of those are characters that are IP that's owned by Nintendo, but they're using it for the purposes of parody. Pretty much all of SNL is going to be parody for the most part. So that's an example of fair use. Now, in this particular case, as to the copyright claim, at the very least, I think that this case, that this use of this footage falls under commentary. And so there's several things that you have to analyze in order to determine whether or not this is properly fair use or whether it's just downright copyright infringement. So one of them is that the use of the copyrighted work has to be pretty closely tied to whatever fair use exception you say that it should be. Meaning you can't just include an entire movie and then say that like, well, I'm using it to comment on it if you've only commented on a tiny bit of it. It's very context specific, in other words. So courts will look at, for example, whether one factor is whether or not you are using it for monetary gain, or if you're just using it just to educate. That's a factor. If you're using it for monetary gain, courts are going to be more likely to say that it's not fair use. But that's just one factor. Probably a more important factor is the amount of the work that you are using in your content, and essentially the percentage of, like, let's say, for example, we're talking about a movie, and it's like a 2-hour-long movie. Are you using an hour and a half of that for your content, and you're actually just showing an hour and a half of it, or are you using a 30-second clip? Because if you're using a tiny little clip of it, that's going to be more likely to fall under fair use, because you're kind of paring it down to whatever it is that you need in order to comment on it. So at the same time, it also kind of depends on how much of that work fills up your content. So again, using a movie, if it's a 2-hour-long movie, and it's a 30-second clip, but your content is only 32 seconds long, then that's a significant portion of your work, right? So you kind of have to look at those two things. And looking at this particular case, like I said, the video in question, let me see if I can pull that back up again. Bear with me once again. Okay, so this right here, so like I said, it's a 2-hour-long live stream podcast, right? And the conversation about this fight was about 10 minutes of the 2 hours. And then of those 10 minutes, about 54 seconds of that was footage that was shown. So on that, it seems like that's a very small portion of not just the fight, because it looks like, at least, I don't know exactly how long the fight lasted. However, I do see here that at least this video itself looks like it's about 14 minutes long. So under a minute versus 14 minutes, I don't know. Yeah, so it's such a small portion that's used here that it seems like kind of a nothing burger. And on top of that, like I said, the entire time that this video was playing, Ethan Klein was talking, his video was right here. He was talking about how this is just, showing what it was that he was talking about before the footage was rolling, that, that these guys were in kind of disparate situations, that Jake Paul is this new young guy, and Ben Askren is kind of this sort of a has-been, if you will, and that the fight wasn't fair, and that he's only going to respect Jake Paul's fighting abilities if he really goes up against somebody that's in his prime right now. So in terms of fair use, I really do think that this falls under commentary, the commentary fair use exception to copyright. So I think that the way that fits with the overall complaint, it's the copyright claim I think is bogus. As for the other ones, I mean, I'm not going to get into them, but I don't know. I just don't think that it's a very good lawsuit, to be honest. So, okay. So aside from that, what I really want to talk about here is this crazy number for damages. Oh, we have another comment here. Psychotic Doll, thank you for watching. This case feels like a waste of a lawsuit. If Triller was that upset, they could have filed copyright strike or claim through YouTube. That is also true. That is also 100% true. They could have filed, something through the YouTube process, and it doesn't look like they did. I mean, the video's still up. I don't know if it's still monetized or not. But and you're absolutely right about that. So you're saying that the fight was faked. Oh, I have no idea. I have no idea if this fight was faked at all. I didn't watch it, to be completely honest with you. But I just know what some of the commentary has been on the fight. So uncivil law, the fight was so short, every single person who bought a pay-per-view ticket has a claim for fraud in the inducement. Thank you, Kurt. That was a good one. I mean, I heard that he knocked him out in the first round, supposedly, but I don't know how long that was. Leonardo Aguilar. So do the people who watched it on websites that got taken off the lawsuit, will the viewers get taken to court like how Triller said they will? I mean, look, I don't know. Maybe it's possible if they can find them. Like that's really the big the big issue here, right? Is because the ability of them to find them is really the biggest hurdle for them. I doubt it. I personally doubt it because, in their statement, they talked about how they were even going to find people despite the fact that if they were using VPNs or whatever. And I don't have perfect knowledge on VPNs and how they work. However, I do understand that usually VPNs that you pay for are the ones that are going to protect your information because they generally don't keep a log of your information. So even if Triller tries to file, through one of these lawsuits, they request information from these VPN companies. They ask for all of their information for people that are that streamed that particular fight through particular websites. The VPN company can only give them what they have, right? If they don't keep logs of that information, they're not in the habit ever of keeping that kind of information. There's nothing to give. So then I don't know how they could possibly get that information if the VPN companies don't keep that information, right? So that's one hurdle there. I personally don't think that the individual people, that the 2 million people. Here's another thing about it. In order to find people, it takes a lot of time and a lot of money. So trying to find 2 million people that are just random people around the world that streamed this fight, I don't see how Triller can possibly have the resources to track every single one of them down. and to try to find them. It's hard enough trying to find, you know, an heir to a particular estate where they're in some random part of northern Canada, and you have to snowshoe out to get them when there's a substantial estate involved. You know, in this particular case, we're looking at getting damages from individual people who watched this of $50 per person, because ultimately what the only thing that that Triller can really ask for from the people that just watched it, not broadcasting, not publishing, right? Because all of these other counts here that are under the Computer Fraud and Abuse Act, the Federal Communications Act, you know, copyright, federal copyright law, et cetera, et cetera. I mean, these are laws that are aimed at people that are intercepting pay-per-view broadcasts and then republishing them, not necessarily just for watching them. And I don't know of any case where someone has successfully sued an individual for watching an improper broadcast of something. That's not to say that it will never happen or it can't happen, but I just don't know of any. And then on top of that, in terms of what it is that they are going to have to pay, like let's just say that Triller, in their, you know, infinite resources, has the capacity to find every single one of these people, and they are they're able to find them all. They file lawsuits against each of them. What is it that they can get from all of these people? They can basically get compensatory damages from them. And I'm going to talk a lot more about damages in this case. But, you know, for these particular individuals, since you asked this question, all they can really get is what they would have gotten from these people had they bought that streaming through pay-per-view. And that's $50. So we're talking about finding 2 million people so that they can just get $50 out of them. That's a lot of resources that they're going to have to pay to try to find these people just to get $50. It's not going to be worth the money. You know, yeah, the juice is just not worth the squeeze. So going through some more of these comments. Michael Oninas, uncivil law, funny joke. Good thing the pay-per-view covered all the undercard. Yes, it was a good joke. It was a very good joke. Okay, so it's been alleged he got knocked out in the first round. So yeah, that was apparently what happened. But I don't necessarily know that means that the fight was fake. It could have been real. I mean, it could have maybe Ben Askren had an off day. Who knows? So anyway, so I want to talk about the damages here. I don't want to, you know, languish too much longer on this topic, but so, you know, like I said before, I pointed out at the beginning of the stream, I guess towards the beginning of the stream, that on the docket it said that the demand was for like $1 billion. I mean, that's like Dr. Evil $1 billion status here, because I don't see how on these facts and using these laws that they can get to $1 billion or even 50 million, like they say here. So going down to the prayer for relief, the part down here. Yeah, this is a good one. Carahan, thank you for watching. Triller, we will find you, turn you upside down, and even take your lunch money. I mean, that's basically kind of what this kind of really comes down to in reality. They want to make it seem like a super intimidating, scary lawsuit, but to me, it just looks like basically trying to take people's lunch money. That's pretty much it. Okay, so going to the prayer for relief here, where we're talking about damages, they are saying, so jail time to allegedly. So in this particular case, okay, let me just explain something about jail time in relation to this case. So this is a civil case. A civil case basically means that you have one private individual or an entity, like Triller. Triller is an entity. It's not a person. It's an LLC filing against another person or an entity. There's no the government is not a party in this case, right? So criminal law is where you have the people that are suing the defendant. It's the people versus Derek Chauvin. It's the people versus O.J. Simpson. And that is, there's a criminal indictment that happens. There's a whole different process for a criminal case than there ever is for a civil case. So this is a civil case, and it's always about money, either about money or occasionally about either asking the court to make someone do something or to make them stop doing something. So that is when they're asking to have the court enjoin the defendant from doing something, like to prevent someone from knocking down a historic house, or to prevent a factory from operating because they are spewing pollutants into the air and the neighboring residencies, are getting poisoned by it or something. So that's another way that civil lawsuits can ask for a remedy. But usually these cases are all about money. A civil case cannot end in jail time. The way that it would work to end with jail time is if a government entity saw this case and was like, yeah, you know what, we should also indict this person. Usually it's going to be for a very, very serious situation. And I think this case, like I said, I already went through the copyright situation and the fair use defense that H3 podcast can use on that one. I don't see any universe where Ethan Klein or anyone connected to the H3 podcast is going to jail over this. So that's what I have to say about that. Okay, so in order to get to a place where they are asking for $50 million, let's do some math here. So under copyright, so under the first count, the first count is for copyright. So you have to follow, in order to ask for a certain amount of money, usually, especially when we're talking about a particular statute, usually they're going to have certain guidelines on what you can ask for in terms of damages or other remedies, for example. So when it comes to copyright damages and the Federal Communications Act, so counts 1, 2, and 3, all of these basically say that that they can ask for, that the plaintiff, so before I really get into this, I want to look at the damages situation in the most favorable situation for the plaintiff, right? Like, what is the most that they can ask for here? So basically, I'm just going to assume that H3 or that Triller is able to prove everything. They are like, it's like Dogecoin going to the moon, right? Like they are rocking on everything. So the max that they can ask for, I'm going to try to calculate that here. So for copyright and for the Federal Communications Act, they can ask for what's called compensatory damages. That's also known as actual damages. Basically, it means the amount that the plaintiff lost because of the defendant's wrongdoing. That would be essentially, in this case, you could calculate that as lost sales. So so I know earlier I mentioned that Triller had said that they estimated that they had lost about 2 million viewers because of these websites that were streaming illegally, right? So in this particular case, like I said, the video on H3 podcast got around 1 million views. So we can't possibly say that they're responsible for all 2 million, right? The most that we can say is that they're responsible for, where is it? I wrote it down here. I can also look back at the website, but I also wrote it down here. Let's see if I can find it. Okay, 1,058,364 views. So that is the absolute most that we can say that Triller can argue that H3 podcast is responsible for taking away viewers from pay-per-view, right? And another important detail here is that H3 podcasts showing of this content was not live. it was at the time that Triller is offering their replay. So not for $49.99. That's apparently how much they were charging for the live showing, but rather $23.99 for the replay. So the most that they can calculate the compensatory damages on this one, in other words, the lost sales because of this video, is 1,058,364 views times $23.99. That leads to $25,390,152.40. So you got that? Basically, 25,390,000. Let's say that. That's how much that if they prove absolutely everything. Now, on top of that, they can also ask for the infringer's profits. So, in other words, if that 25,390,000 doesn't adequately cover the harm basically that's been suffered by the plaintiff, they can also look at how much H3 Podcast made from this video. However, they have to be able to show that the profits that H3 Podcast made from this video actually come from the streaming of this content, not from the rest of the content that's on the podcast, not from the fact that they have almost 3 million subscribers in their own right, the fact that their videos regularly get 2 to 3 million views per video. I mean, and like I said, this video got around 1 million. So this is not even one of their biggest videos. So in order to get, more damages out of the infringer's profits here, right? Like, it's assuming that H3 Podcast is determined to have infringed. They have to be able to show that whatever ad revenues, sponsorship deals, the merch revenues that they have, that's also linked to their linked in the description there. They have to be able to show that whatever money that they made from this, or they have to be able to show that a certain percentage of the money that they made from it is due to the fact that they stream this content. Now, it is true that the video is called Jake Paul Fight Was a Disaster. So people may have clicked on it thinking that this was going to be about the Jake Paul fight. However, there's nothing in the title that says, watch the Jake Paul fight here. It's just saying Jake Paul fight was a disaster. That's an opinion. That's somebody's opinion. That's someone's commentary. So for all anyone knows in leading up to clicking, and by the way, this is assuming that the title hasn't changed since April 22nd, because titles can change on YouTube. I know that. I've done it myself. but assuming that it is the same that it was on April 22nd, there's nothing in this title that suggests that, that it's like asking for people to come and watch this video, because if they do, they'll get to watch the fight. And they'll get to watch the fight that they otherwise would have to pay $50 for, or $23.99, $24. So that's a big issue in trying to ask for these profits from H3 Podcast as damages as well. So then on top of that, for copyright, they can ask for statutory damages up to $30,000. However, that's only if the work in question, the underlying, the streaming of the fight, if it is actually registered with the U.S. Copyright Office, either before the infringement or within 3 months of the publication. So not obviously. My understanding is that this was not copyrighted ahead of the actual streaming of this podcast, right? On April 22nd. They potentially could obtain a registration for a copyright in the next 3 months, I guess. But I mean, as far as I know, it doesn't seem like they're actually asking for those statutory damages under this count, because they said, 50 million here. And what they're saying is they're asking for the plaintiff to be awarded all profits of defendant plus all losses of plaintiff, the exact sum to be proven at trial, but in no event less than $50 million. So there's nothing here that's talking about statutory damages, but I just thought that was worthwhile talking about as a possibility. But I don't think that that's possible, so I'm not going to add that into the calculation. So we've got this figure still for $25,390,000. That is the absolute most so far that that Triller would be able to ask for. The infringer's profits, I don't know. I mean, it's my understanding that, I looked them up briefly on Social Blade for whatever their ad revenue is, and it looks like the ad revenue for H3 podcast is somewhere between 10,000 per month and like 158,000 per month. So, dividing that across 12 or 13 videos per month, that was let's see, where is it? Okay, I had this here. That's somewhere between $770 per video and $53,000 per video. So the absolute most, well, not the absolute most, but considering the average for this channel, most likely the amount that they made in ad revenue, not including sponsorships, is somewhere around $800 to $53,000. Not quite close to 50 million, right? So I'm going to look first at some of these other counts and sort of add these up and see how far we get, right? So now, as to count 2, they're talking about, now this is back to the Federal Communications Act, which has, like I said, it's another statute, and they have certain guidelines for how you can ask for different remedies. And basically, the max that they would be able to get, they say it's $110,000 for per violation for defendants' willful violations of this code. And I would agree that under the statute, it does say that the max in this kind of situation, the max that they could potentially ask for is $110,000. I don't think that it is violating under this code in the way that they are arguing necessarily. And I don't think that they would be able to ask for $110,000 because, so $110,000 under this particular statute is, like I said, it's the max, and it depends on the circumstances of the lawsuit, right? It depends on the fact pattern. It depends on how bad or how egregious the violation is. So if this is just someone, if this is just a podcast that thought that what they were doing is talking about a particular social media event, right? This is a YouTuber that we're talking about, and this is a YouTube drama channel that we were talking about that is talking about this YouTuber who's now boxing or, doing MMA or whatever. So, if they have this idea that they are able to comment on this and to show some footage from the fight, because, that's often what happens on these kinds of channel. It's not the kind of situation that to me sounds like, oh, this is so egregious, this is so horrible, that they are just like wantonly taking this, this footage and putting it out there so that people can get around paying for this pay-per-view fee. So I don't think that the facts in this case warrant asking for another $110,000. But let's just assume, let's just say that that the judge is taking crazy pills and decides to add that to it. That brings us to $25,530,152, or $25,530,152.40. And that's actually adding in the copyright statutory damages that I mentioned before that are likely not applicable in this case. So adding on to that, the next one, I'm gonna get through this a little bit faster here. For the next count, the statutory damages that they could potentially add on to it are $60,000. Let's just assume they win. You add another $60,000 to that. We're still not even to $26 million. And that's it. I see absolutely no way that this case gets to $50 million. And from the reading of it, I can see how some people might take a look at this complaint and think that what would happen is they would add 50 million to 50 million to 50 million to 110,000 to 60,000. You know, like this is over $200 million that they would be asking for. That's not the case, because what we're talking about is one central action, right? All of these are different causes of action, but they're all based on the same circumstance, the same fact pattern, the same, you know, it's not like there was a series of acts. I mean, unless, like I said, unless that there is more information out there that I'm not aware of. But if it's just this video, we're talking about just one video upload, one, you know, broadcast where they are using it for commentary and they're talking over it the entire time, and it's such a tiny little snippet. So you wouldn't be adding on the 50 million to 50 million to 50 million. No, the 50 million here in each of these counts is for the same initial calculation that I talked about, which is for compensatory damages plus the defendant's profits that they got from doing that, because the courts don't want to let them have a windfall on this, right? Courts never want to allow a defendant who acted wrongly to be able to profit from it. So they want to be able to award that over to the plaintiff as well. So anyway, so I really think that in this case, like I said, I see absolutely no way that this case gets to 50 million. I think that at the very, very, very most, from what I've calculated, the absolute max, and like I said, this is like if they were to prove everything. And mind you, when I did the calculation for compensatory damages for how much Triller may have lost because of this video, you know, this is 1 million views, calculating $23.99 against roughly 1 million views. That is also assuming that it can be proved that every single one of those views was someone who would have bought the access to pay-per-view and didn't because they watched this video instead. So no idea if any of those people watched this video because they had already watched the pay-per-view video and wanted to see commentary on it. No idea if people watched this video and had absolutely no plans to watch the pay-per-view content. Absolutely no idea. So I don't know how Triller would possibly prove that either. So like I said, like I don't think that it would get to $25 million. I really don't think it would. I really, really, really don't think it would. But the absolute most that they could possibly ask for. So with that, I think that my impression on this lawsuit, the bottom line is, I personally think that this is not the scary case that a lot of people have made this out to be. I know that this is you know, centering on a YouTube drama channel, and a lot of times, you know, this kind of legal drama can really spur a lot of interest and a lot of other commentary, and it kind of gets everybody up into a frenzy. But I really don't think that this case is this isn't it. The facts are not there, and this analysis is a little bit wonky. And what they're asking for is it's really unrealistic. Incredibly unrealistic. I don't know how they got to 50 million other than just scrawling a number down on a wall, and they're like, this is what we'll ask for. It's crazy, but we can somehow figure it out. So, I mean, if Triller came to me on these facts, like I said, I'm an attorney. I'm licensed in California. I'm licensed in DC. I've done litigation for years. If Triller came to me and said, hey, we want you to represent us and to sue these people on these facts, I wouldn't want to take this case. I wouldn't want to take this case. I wouldn't want to be an associate at this firm working on this case. It would be kind of a nightmare. I really don't think that this is a good case, personally. So then the question is, why did they file? There's some possible ideas. I mean, maybe it's a money grab, you know, like I mentioned earlier, they did have their you know, offer to settle against all these people that they likely won't be able to find. You know, these people that supposedly watched the streams through unauthorized means. You know, that may have been a bit of a money grab. It may be a publicity stunt. It may also very much be. And because to be completely honest with you, I mean, look, I've got this YouTube channel, but I'm not always completely up on all the new, social media stuff. And I had not actually heard of Triller before this whole lawsuit. And now I understand that they're trying to compete with TikTok. And they have been for a while. So it could also be that they're trying to get the Triller name out there, as for people to find, to learn about Triller and to maybe look them up. I mean, it obviously got me talking about it. But yeah. So anyway, that's what I have to say about that. It may just be a publicity stunt. Here's another question. Would there be an arrangement for H3 to somehow pay that? Or just one whole payment of $50 million? So okay, let's just assuming that this is a successful case. I don't think that it will be, but they may try to settle this case, in which case they would settle for a much, much, much smaller number than this. Way smaller. If I were H3 Podcast's attorney, I mean, I would start the negotiations at a laughably low number, because I don't see the facts in this case being anywhere close to what the plaintiff is alleging them to be. So what happens with, settlements and with these kinds of monetary judgments? They can be paid in installments. They can be paid in a lump sum. I mean, I've primarily seen settlements because the vast majority of civil cases settle. It's very rare to find a civil case going to trial, partly because they're so backed up, and the courts tend to be so backed up, and partly because it's judges tend to favor these cases to settle out, because sometimes it's just, the juice is just not worth the squeeze, and it's a lot better for everyone if they can resolve it earlier by negotiating and sort of working things out through a process of mediation, and just kind of resolving it that way. Because otherwise the litigation process can take years and years and years, many years. So anyway, yeah, it's sometimes an arrangement can be made to pay amounts in a lump sum or in, over time. That's what I have seen, in my experience, is primarily with settlements has been, defendants paying over a period of time. Like they'll agree to that when when we're working out a settlement agreement, right? Because we're a settlement agreement, it includes all of the terms of the payment and dropping the lawsuit and how and when and where. So all of that is worked out on paper, essentially. So my claim is maybe they can pay it in an installment plan, $1 per month. That would take a very long time. Well, maybe not. Maybe it wouldn't take a long time, because maybe it would be such a small amount, right? Yeah, it scare all the peoples into paying their settlement fee. Yeah, that was maybe the purpose of the offer that Triller offered, that Triller made, to all of these people that were viewers, apparently. So how low? $2,000? I don't know. I mean, I don't know. Part of it is, so when you're making an offer for a settlement, part of it is, what goes into it is the facts of the case, and then on top of that, also the appetite that the party has for lawsuits or for making a certain payment. In this case, but I mean, I would start it pretty damn low in this particular case. Okay, Psychotic Doll. My question is, what kind of lawyer would agree to take this case? Not a lawyer and a total idiot, but this feels like there's no chance of this getting far. Yeah, so like I said earlier, I don't want to disparage any members of the California Bar, any fellow members of the California Bar, because I just, the legal field can get very, touchy, I guess we can say, especially in litigation. People can get very, very heated, even when they're supposed to be kind of emotionally detached as an agent for a party. I'm wondering why they took this case as well. I don't know if sometimes look, we're also in a pandemic, so some firms are also struggling. So maybe they figured this is business that was coming in the door, and they didn't want to turn away business if it was coming in the door. That's always a possibility. Somehow they just decided that this was a good case. I don't know. Maybe they have information that I don't have. That's always a possibility as well. Anyway, here's another question. Would the streamer be liable and the viewers protected from unauthorized streams? So first off, I just want to make it super clear. I wanted to say this earlier and I didn't, but I want to make it clear now that for one thing, everything that I'm saying here is not legal advice. So all this is legal opinion. So if anyone here, and I'm not saying that Dominic Booth is, but I don't know, maybe someone else here is watching this and is thinking that they watched the Triller, not the Triller stream, but one of the unauthorized streams, and that may be one reason why they're watching this. Don't rely on this. If you are concerned about your situation, talk to a lawyer individually. So I am an attorney, but I'm not necessarily, the fact of me doing this live stream and doing all of the other videos on this channel doesn't make me your attorney. So don't rely on what it is that I'm saying. I'm giving my legal opinion, and other lawyers can have other opinions as well. That includes other YouTube lawyers. That includes other lawyers that are otherwise practicing in law firms around the country. So with that said, my personal opinion, it depends on the facts that come out in the case, whether or not that the streamer would be liable. Right. So in this particular case, the facts that I have found, the facts that I have seen, either what's been alleged in the complaint, and what I have seen on H3 Podcast's channel, which I haven't seen all of their videos talking about the Jake Paul fight, but I saw this one that was on April 22nd. I personally wouldn't see this case going so far as to say that they would be liable. That's my personal opinion. And that's a separate question, asking about whether viewers are protected from unauthorized streams. In other words, if you're asking if people who had viewed these unauthorized streams, if they would be protected, that's a separate question than whether or not the streamer would be liable. Because it's like two separate facts, two separate fact patterns, really, because you've got two different people, two different actions. Right? There's the upload, and then there's the download. Those are two different people doing two different things. So that would require its own analysis. But personally, I don't think that these people can be reached, like I said earlier. So I think that I doubt that there's going to be some mass lawsuit that's filed by Triller against 2 million people for watching. For watching this through unauthorized means. So, okay. So I think that I probably have gone on long enough on this, but I really appreciate you guys watching and commenting. These have been some very interesting questions, some great questions. And I hope you enjoyed this. So if you guys did, I would love it if you'd hit the like button. It does really help us with the YouTube algorithm gods. It helps us grow. We just surpassed 3 million. Not yet, not quite yet. We just surpassed 3,000 subscribers, recently, a week or two ago, something like that. And we're on our march towards our first 10,000 subscribers. So we're almost a third of the way there. So if you guys want to help support us, you want to see more content like this, we would love it. We would really love it if you would hit the subscribe button and the notification bell so you can see more stuff like this. And if you absolutely really want to support us, you can also head to our Patreon page as well. So I don't have that linked right now in the description, but I can change that real quick. So anyway, I hope you guys enjoyed this. So, all right. See you guys. See you in the next video.